Morning, members. Morning to the delegation department. May we find out who's going to the vote amendment bill presentation so that we can give him powers to share?
Sorry, I didn't hear your. You wanting to know who's doing the who's presenting on the salaries?
No, DM, morning DM. No, I'm aware that you will be taking us through the salaries, so there's no presentations to that. I'm asking the colleagues from for their presentation on the bill.
Oh, the divorce. Let me check. Let me check.
Good morning. This is Alison Boerter from DOJ.
Good morning, ma'am.
Good morning. My Chief Director, Advocate Meta, and I will be doing a presentation on the Divorce Amendment Bill, but we're doing it on a cell phone because the network is not stable on the network right now on the laptop.
Recording in progress.
If you would possibly be able to flight the presentation while we talk through it.
Okay.
Thank you.
Good morning to everybody. Welcome to this meeting after a long recess. Let me welcome all members and everybody watching from the virtual platform and those who are watching from home. Welcome, Deputy Minister. We are going to have a short day today because most of us will have to join the other committee on the public protector. So we must be done here at least by 10:30 because the next meeting is starting at 11. The Deputy Minister is going to lead us on the remuneration briefing for the public protector, South African Human Rights Commission, the judges, and the magistrates. Over to you, Deputy Minister.
Thanks, Chair, and good morning, members. Yeah, this is basically on the determination by the President of the salaries for the judicial officers, the judges and magistrates, and then also the two bodies that the Portfolio Committee deals with, the Public Protector and the Human Rights Commission. It's effectively a determination by the President, but as the President, it's not really appropriate for the President to come and explain. I, on behalf of the Executive, will be doing it. And I think in the past, I've done it and my predecessors have done it. But you basically, in terms of the law, and if I can deal with the two together to begin with and then separate out later. The judiciary and the independent constitution institutions are entitled to such remunerations, that's salaries, allowances, and benefits, as determined by the President from time to time by notice in the Gazette, after taking into consideration the recommendations of the Independent Commission for the Remuneration of Public Office Bearers. The notice by the President must be submitted to Parliament for approval or disapproval, whether in whole or in part. And the determination by the President is with effect from the 1st of April last year, 2022. That is for the last financial year, 2022 to 2023, till the end of March 2023. As the committee should be aware, the Independent Remuneration Commission only gazetted its report and recommendations on the 21st of April this year. for the Remuneration of the Public Office Bearers Act. It's the same, basically the same report that from which the determination, and the same determination was made for members of Parliament as their increase. The Independent Remuneration Commission, after having considered, amongst others, the submissions from the various stakeholders, the fiscal conditions of the state's wage bill, previous determinations, the impact of the salary increment on the public office bearers on the fiscus, and the general economic status of the country as it's recovering from the effects of the COVID pandemic, recommended a 3.8 salary increment to the President for all office bearers for the 2022-2023 financial year, with effect from the 1st of April 2022. Having considered the recommendations of the IRC and the serious economic challenges facing the country, the President is intending to determine a 3% increment for all ranks of judges and magistrates, as well as the constitutional institutions such as the Public Protector, the Deputy Public Protector, and the Commissioners of the Human Rights Commission, subject to the approval of Parliament. The President submitted the determination in respect of the remuneration of the judges and magistrates to both Houses of Parliament on the 28th of June this year, and on the 8th of August, the President submitted his determination in respect of the remuneration of the Public Protector, the Deputy Public Protector, and the Human Rights Commission to the National Assembly. With the judges and magistrates, it's both houses that have to approve. With the Chapter 9s, it's only the National Assembly. So it's recommended that the Portfolio Committee consider and approve the notices by the President for the 3% salary increases for all ranks of judges, magistrates, as well as the Public Protector, the Deputy Public Protector, and the Commissioners of the Human Rights Commission from the 1st with effect from the 1st of April. That's the presentation, Chair. You should have, or the members should have, the draft notices or the letter by the President to the Speaker, the draft notices, as well as the Gazette with the IRC's report in it. I can answer questions if honourable members have them, or try and answer them. Thanks.
Thank you very much, Deputy Minister. Members, that is the presentation from the Deputy Minister. Are there any questions? I have Honourable Swart. Okay, Honourable Swart, proceed.
Good morning, Chair. Good morning, Deputy Minister and colleagues. I appreciate the Deputy Minister's presentation. And I also appreciate that the initial determination was made by the Independent Commission, and the President then made a further determination decreasing from 3.8% recommended to 3%. The issue which I want to just raise is that the Minister raised a concern about the late submission of the Independent Commission's recommendation, which in his view indicated that it does not allow significant time to deliberate and engage with the stakeholders and, of course, the judiciary. Whilst I appreciate the Deputy Minister can probably not respond on behalf of the Independent Commission, but what steps can be taken to ensure that the recommendation is made earlier as opposed to the 21st of April this year, which limits the time for engagement. And then secondly, the Chief Justice asked the Commission to consider the inflationary erosion of judges' salaries. And the judiciary provided an overview which indicated a total shortfall of minus 20.6% over the years. Now, the response by the Commission was to indicate that the whole issue was being addressed and there was a major review. Now, again, I'm not sure if the Deputy Minister can respond to this, but possibly he or the Executive will be able to take it up with the Commission as to when this major review of the judicial salaries will be concluded and how long the process is ongoing. Thank you, Chair, for allowing me those few questions for clarity.
Thank you very much, Honorable Masego Jele.
Thank you very much, Chairperson, and good morning, colleagues, and also the DM and the team. Chair, let me welcome the report from the Deputy Minister without waste of time. I went through the report, and I saw that there was a there was a recommendation of 3.8%. And also now the president is recommending 3%. I think I'm going to go with support the view of the 3%, Chair, considering the situation that the country is facing right now. Not that we are not acknowledging and also recognizing the good work that is done by our public protector and Chair, we just want and others, but we want to say I support that 3%. Thank you.
Thank you very much. Any other hands? None. Before we go to support and those who might not, Deputy Minister, can you respond to the questions asked by Honorable Swartz?
Thanks, Chair, and thanks, Honorable Swart and Honorable Maseko Jele. As far as the Commission, yes, it's been. We used to be able to do this before the end of the financial year, which also meant that everybody got taxed on the tax rules for that financial year, whereas we've all had to be taxed in terms of the new financial year. That would include the magistrates and the judges and the people who haven't received the increases yet. I think I'd raised last time, I mean, as Honorable Swart says, the Minister did raise concern. He raised that in his letter to the Commission. I think when I did this exercise last year, I did suggest to yourselves that I don't think there's anything stopping you from Parliament from calling the Independent Remuneration Commission in to find out why they are getting later and later. Just remember, though, that there's also other Chapter 9s whose salary increases are done by other committees. So the Cultural Linguistics in particular and the Gender Commission. But you may want to look at that. As far as the review, I understand that they are intending to have that. According to our info, the Remuneration Commission will submit their major review at the end of this financial year. And then maybe just to say that, look, by way of background, the Minister of Finance didn't support the 3.8% increase. He proposed a 1.5% increase plus a once-off gratuity. The Minister of Justice supported the 3.8% increase. It is correct. I mean, there's also a particular problem with magistrates because a lot of magistrates come from the NPA. The NPA are public servants and they benefit from the bargaining the negotiations in terms of the Labour Relations Act. So they've generally got all public servants have got a inflationary linked increase every year. So what the effect of this is that the NPA prosecutor salaries have been increasing at a greater rate than the magistrates. And that is going to cause problems down the line. because then why would a prosecutor want to become a magistrate if they're earning less? We have in the past managed to get magistrates increases, more increases than other people. So I think the biggest success, and one of the other problems, is the gap between magistrates and judges' salaries. It's quite extensive. Judges also don't contribute to a pension because they get their salary for life. But in some years, magistrates got more than judges, but it's still less than what the public servants were getting. So that is a longer term issue that I'm raising this year. It is, as it was the previous year, it is 3% across the board for everybody, and that includes members of the executive, cabinet, the members of parliament, provincial legislatures, etc. So I hope that answers, but Chair, I would suggest the committee could look at calling the Independent Remuneration Committee. Thanks.
Thank you very much. I think that should form part of our legacy issues. We would, even if we wanted to, would not be in a position to add more work between now and the end of the year. Maybe I would suggest to the committee that that recommendation, maybe it forms part of our report, and so that the 7th Parliament can look at that issue. Will that be okay, members?
Yes, Chair.
Yes, Chair.
Thank you very much. There is a move to second the report, in fact, the 3%, by Honorable Maseko Jele. We're not adopting the report now, but I just wanted to get the feeling so that tomorrow we are able to finally adopt the report. Are there any comments, members? Or are we fine with the 3%? Honorable Ngola?
Yes, thanks, Chair. Chair, in a fiscal constrained environment, I think 3% is reasonable. So I support the views echoed by Honorable Maseko Jele. Thank you very much.
Thank you very much, Honorable Ngola. Honorable Breitenbach?
Thanks, Chair. Good morning. We'll reserve our position.
Yes. I guess we will still do the same tomorrow, because the adoption of the report would be tomorrow. Thank you very much, members. Thank you very much, Deputy Minister, for leading in this presentation. Members, before we go to the divorce amendment bill, you would be aware that the Chief Justice has written to the Speaker of the National Assembly with regard to the issue of Judge Mutata, that the referral letter has been sent to us. I will ask the committee secretariat to distribute the letter. What I propose we do, members, is that as we know that our program is full, is to, if we get a mandate from the committee, that we go and rework the program so that we try to accommodate this issue, because it's quite urgent within this term. That would mean that we must work longer hours to finalize the other bills. But I would plead with the committee that we be allowed to go and rework the committee to see how to accommodate this issue, this referral. Will that be in order, members? Honorable Chair.
Yes, Chair.
Thank you, Chair. Yes, I have no difficulty with the suggestion. Just the matter is extremely urgent. We should try and do it as quickly as possible.
Yes. No, we will do that, members. So there's no objection. can we move to the next item? Maybe before the next item. Members, as way of accommodating also this last issue, we have tried to inquire with parties as to whether we can be able to sit on Thursday, just to try and push the Judicial Matters Amendment Bill. I have not received objection, but it was only the EFF that did not respond, to the best of my knowledge. Is it possible, members, that we can meet maybe Thursday, half a day, and try and push the Judicial Matters Amendment Bill?
Fine, Chair.
Thank you very much.
Okay.
Yes, Chair.
I've got no objection. I just wondered when we will know, because I understand special leave had to be applied for. When will we know whether we are sitting? And I presume, will it be a virtual meeting?
Yes, it will be a virtual meeting. Committee Secretariat, have you received any response from House Chair?
We'll follow up before end of business today, Chair, but they've received the application, the processing, Chair.
Okay, so we'll communicate with members immediately after we have received a response from the House Chairperson. But let's try and reserve at least half a day to deal with the Judicial Matters Amendment Bill, so that we can have enough time to finalize other bills. In these 4 weeks, we must finalize 4 bills, which is going to be a mammoth task, and the issue of Judge Mutata. So we are going to meet more often, and we are also going to apply to meet during sittings to ensure that this work is done. Can we now move to the next item, that is the Divorce Amendment Bill? Who is leading us there?
Chair, the department has a presentation. I mean, just to say that this bill was introduced. I think it's still been advertised for public comment by Parliament,
Yes.
Which I think expires early next month. So this is, I think, just a briefing. The issue was that in terms of the Women's Legal Centre, Justice and Home Affairs had until, I think it's sometime in June, to amend to give effect to the judgment. Home Affairs is working on a new Marriages Act, which will include divorce, but which, as you know, I think has been published for public comment. But as you know, it's not going to be completed before the elections. So we basically brought this bill as an interim measure to comply with the Constitutional Court and effectively the Supreme Court of Appeals declaration of invalidity, which would be in effect until those other processes are finalized. So that's the background to the bill. It is trying to comply with the Constitutional Court judgment only. If I can then hand over to the officials. The Chief Director, Sebele Mecha, is here with his team. But if I can hand over to them. There was an issue earlier before you joined. If they're not able to, because of connectivity problems, flight the presentation. So I think the committee section will be flighting the presentation. Thanks, Chair.
Thank you very much, Deputy Minister.
Good morning, Chair and honorable members. If you may allow... Should I proceed, Chair?
Yes, please.
Yes,
Please.
it's a civil image. I'm with Ms. Alison Botha. If you allow, she'll be taking us through the presentation, Chair.
Thank you.
Thank you.
Good morning, Chair. Good morning, members.
Morning.
Let's, if we can, jump straight into it. I'll be starting on the slide that's titled Background of the Bill, WLCT Judgment. Thank you. So on the 28th of June 2022, the Constitutional Court handed down a landmark judgment, and that's the WLCT case. And it's important because it recognized the need for and the importance of protecting Muslim women and children of Muslim marriages on the dissolution of a Muslim marriage. And the background to that case is that it stems from 3 separate applications brought in the High Court, which were then consolidated in the Constitutional Court. And in the WLCT case, the Concord held that the Divorce Act was unconstitutional to the extent that it failed to recognize Muslim marriages which have not been registered as civil marriages as valid marriages. Further held that the Divorce Act was inconsistent with sections 9, 10, 28(2), and 34 of the Constitution. In particular, sections 6, 7(3), and 9(1) of the Divorce Act was specifically declared to be unconstitutional. The next slide, please. The Constitutional Court suspended the declaration of constitutional invalidity for a period of 24 months from the date of the order to enable the President and Cabinet, together with Parliament, to remedy the defects by either amending existing legislation within that time or introducing new legislation. We have elected to amend the existing Divorce Act. The Constitutional Court did specify some interim measures which would operate pending the coming into force of the amended Divorce Act. Importantly, the Concord didn't read in an order, so the bill is necessary and urgent and has to come into force before the suspended declaration of invalidity and interim measures lapse. So the bill must come into force by 28 June 2024. The next slide, please. Thank you. The Constitutional Court also held that the Marriage Act is unconstitutional to the extent that it fails to recognize Muslim marriages which have not been registered as civil marriages as valid marriages, as the DM have pointed out. And the department has been working very closely with the Department of Home Affairs, which administers, of course, the Marriage Act and all the marriage legislation, because we have the same deadline of 28 June 2024 to remedy the defects through either amending legislation or passing new legislation. We have been engaging extensively with the Department of Home Affairs on their proposed marriage bill to align timeframes and policy approaches insofar as possible between the marriage bill and this divorce amendment bill. But it's now apparent that the parallel timing of those 2 bills is not possible because of the shortened time frame we have because of the early rising of Parliament due to the elections. And so we have chosen to move forward with this divorce amendment bill. And like the DM said, the marriage bill has now been published for public comment. If we can move to the next slide, please. Thank you. So it's important that the WLCT case and that judgment is a departure from the current position. The current position is that Muslim couples who choose to marry according to Islamic law or Sharia law can only rely on the provisions of the Divorce Act if they also conclude and register a civil marriage. And this bill seeks to amend the Divorce Act in order to address the issues in the WLCT case by providing recognition of and protection for Muslim women and children of Muslim marriages on the dissolution of a Muslim marriage. So the bill will not require separate civil registration of a Muslim marriage in order for the parties to a Muslim marriage to rely on the provisions of the Divorce Act, thereby recognizing the validity of a Muslim marriage for the purposes of civil divorce. If we can move on to the next slide, please. Thank you. I'm just going to go sort of quite briefly at a high level through a clause-by-clause analysis of the bill. So clause 1 defines a Muslim marriage, and it's as broad and all-encompassing as possible to avoid prescribing a detailed definition of the Muslim religion, which may not be accepted by all adherents of Islam, and it also provides legal certainty for interpretation. Clause 2 amends Section 3 of the Divorce Act, and that provides for dissolution of marriage and the grounds for divorce. A Muslim marriage may now also be dissolved by a decree of divorce, so essentially it extends the application of the Divorce Act to Muslim marriages. Clause 3 amends Section 6.1 and Section 6.3 of the Divorce Act, which provides for the safeguarding of interests of dependent and minor children. So it now extends the safeguarding of interests of minor and dependent children of a marriage to include minor and dependent children of a Muslim marriage. And it addresses WLCT order that Section 6 of the Divorce Act is unconstitutional because it fails to safeguard the interests of minor or dependent children of Muslim marriages in the same manner as children of other marriages on the dissolution of that marriage. Clause 4 on the next slide amends Section 7 of the Divorce Act, and that provides for the division of assets and for the maintenance of parties. It does that by inserting a new subsection 3A, which extends the application of the section to Muslim marriages. It extends the application of subsections 4, 5, and 6 to the new subsection 3A, and it extends the factors which the court must take into account when deciding an application for the redistribution of assets of a marriage out of community of property to include any contract or agreement between the parties in a Muslim marriage where the husband is a spouse in more than one Muslim marriage. And this amendment addresses the order in WLCT case, which held that Section 7.3 of the Divorce Act is unconstitutional because it fails to provide for the redistribution of assets on the dissolution of a Muslim marriage. The amendment in Clause 4D follows the consideration of an interim measure in the WLCT order. Clause 5 amends Section 9 of the Divorce Act, which provides that a court may order the forfeiture of patrimonial benefits when a divorce is granted on the grounds of irretrievable breakdown of the marriage. So it extends its application to now include a Muslim marriage, and it was amended to address the order of the WLCT judgment, which held that Section 9.1 of the Divorce Act is unconstitutional because it fails to provide for the forfeiture of patrimonial benefits on the dissolution of a Muslim marriage in the same terms as other dissolved marriages. The final slide and the final provisions of this bill are Clause 6, which now provides for the application of the bill to all subsisting Muslim marriages, including the Muslim marriage which was terminated or dissolved in accordance with the tenets of Islam, and where legal proceedings for the dissolution of the said Muslim marriage in terms of the Divorce Act have been instituted but not yet finalized, and which subsisted as at 15 December 2014. This clause was introduced as a result of the interim measures specified in the WLCT judgment. And Clause 6A seeks to protect Muslim women whose Muslim marriages were dissolved only in terms of the tenets of Islam, but in respect of which proceedings were instituted in terms of the Divorce Act for a civil dissolution. Clause 6B seeks to protect Muslim women whose Muslim marriages subsisted as at 15 December 2014 by providing by providing for the application of the Divorce Act to those marriages, regardless of whether that marriage was dissolved in terms of the tenets of Islam. The retrospective application of this clause is limited to balance the rights and interests of Muslim women and children and third parties, and to limit potential unintended consequences. Clause 7 is the short title of the bill. Thank you, Chair.
Thank you very much. Members, that is the presentation. Are there any questions? Honorable Swart.
Thank you, Chair, and thank you for the presentation. And I appreciate the introductory comments that this bill is to be considered urgently because of the Constitutional Court deadline, and that a more comprehensive review is being done by Home Affairs in terms of the Marriage Act. And I also appreciate that the Constitutional Court judgment only referred to Muslim marriages, Muslim divorces, but obviously we also are concerned about Hindu and Jewish law marriages. And I would presume that there isn't time to incorporate those faiths as well in terms of this bill. But it does raise the question, because obviously where South Africans marry under Hindu or Jewish law or other faiths and they don't register it as a civil marriage, they would have the same consequences as the Muslim when it comes to Muslim law and divorces. Was it a consideration at all to include those other faiths? I'd just like some clarity in that regard. Thanks.
Thank you very much. Honorable Maseko Jele.
Thank you very much, Chairperson. I think before I continue, let me just say, Chair, everything and anything that empowers and recognizes the protection and the rights of women, Chair, must be welcomed. We, particularly when it comes to this issue of the dissolution, without waste of time, Chair, let me appreciate the work done by the department. I think I will echo also the views of Honorable Swart by saying we must also look into those other marriages that are still outstanding. But at this particular time, I think I will just leave it there because of the time frame we are responding to the court judgment in the constitutional court judgment, and it is important that we need to meet the deadline. But that consent also it has to be registered, Chair, so that when the seventh administration comes, must also look into that, because to me the time will be very, very short for going through the details of making sure that even other marriages are accommodated. But for now, Chair, let me say I want to thank the department for the work that they have done up to this far, and then also making sure that let's speed up this bill and make sure that the time we don't miss the deadline, the time frame allocated to us. We make sure that, Lord Chair, we meet it. Thank you, Chair.
Thank you very much. Honorable Hendricks.
Thank you very much, Honorable Chair. Honorable Chair, a month after the Constitutional Court judgment, I submit a private member's bill to make amendments to the Divorce Act because of the very strict deadline that after June, South Africa will not have a Divorce Act because of the ruling of the Constitutional Court, and that would throw the whole country into chaos, not having a Divorce Act. The parliamentary legislative drafting team assisted me with the bill. We then got a certificate of constitutional muster, and we have the bill was tagged. We've heard nothing from this committee about my private member's bill until there was a bill that is now before us, and the two bills are very similar. I'm not sure whether the department used the private member's bill to present to Cabinet, which, as you know, approve the processing of the bill. So obviously I would like to have clarity. And then also I want to make the point that I largely left it to the parliamentary legislative drafting team to make the amendments in terms of the Constitutional Court order. The only matter that when I was sitting with the advocate was that Muslim women or anyone representing children should only approach the divorce court after their marriage has been dissolved in terms of Islamic law, in the same way that they got married in terms of Islamic law. That was the only big change that we made to the first draft of the parliamentary legislative drafting team under the leadership of Advocate Samain van der Merwe. So, as you know, Mr. Chairman, we also have amendments to the Maintenance Act because women, not Muslim women, all women are discriminated because men get a travel subsidy and women don't get a travel subsidy. You did mention, Honourable Chair, that by the end of June, the South African Law Reform Commission should report to this committee on what progress they have been made, because the my private member's bill on the Maintenance Act has basically been put on hold by you, and we haven't heard from you after the end of June with regard to that particular matter. Chair, you're also aware of the fact that we submitted a private member's bill on the registration of Muslim marriages. That bill has been debated in Parliament by all political parties. That particular bill is before the Portfolio Committee on Home Affairs for a certificate of desirability. The chairman of that Committee on Home Affairs at his behest, myself and the Minister of Home Affairs have been engaging because now South Africa will have two marriage bills. One bill in terms of the order of the Constitution, and the other bill is a bill that is an aspiration of government to have one marriage bill. Myself and the Minister, we have managed to resolve that particular issue. And so we've had some success, but I'm very disturbed to hear that the Constitutional Court order, there will be non-compliance because the deadline hasn't been met, which means that there are interim arrangements which the Constitutional Court has made, and there was a circular which the Department of Home Affairs issued to try and give Muslim women and children some relief. That circular was flawed, and Al-Jamaa managed to make the necessary changes, so it's a compliance largely with Sharia law.
Honorable Hendricks, can we
Yes.
confine ourselves to the bill before us, not other bills? Can we confine ourselves to this bill because we are getting a briefing on this bill, and it will go for public comments, then we'll come back and debate the bill as the committee. Can we now, the process is just to get clarity seeking questions on the bill before us.
That's fine, Honourable Chair.
Yes, thank you very much. Any other comment? The department, Deputy Minister?
Chair, if the officials can start, I'll come in at the end. So if Ms. Buerter, I think, or Mr. Sebelemecha can come in.
Thanks, Dean. Thanks, Chair. In terms of the question asked by two of the members on concerns raised about divorces for marriages which are concluded in terms of the tenets of other religions, this is something that we did consider. I think in a way this also will address the question raised about whether we use the private members bill on the divorce amendment, the private members bill on divorce. Many permutations of amendments to the Divorce Act were considered, including permutations where we brought in or broadened the scope of this to include the tenets of or the dissolution of marriage concluded in terms of the tenets of all religions or any religion or culture. We had then thought that it would be better to confine ourselves to the WLCT case. And the reason we also took that decision is because of the extensive engagement we had with the Department of Home Affairs. And this engagement began early on, within a month of the WLCT case being handed down. And it was clear to us that the Department of Home Affairs was going to have an all-inclusive marriage bill, which would include the tenets, which would include the recognition of a marriage which was concluded in terms of the tenets of any religion, any culture, because it was going to sort of standardize and give generic requirements. And we can see from the bill, which was the marriage bill, which was published for public comment, that this is the view that they've taken, that this is the approach that they have chosen to go with. And because of this approach, which we understood from a very early stage, we didn't think that it was necessary for the Department of Justice to extensively address that in the Divorce Act, rather that it would be addressed primarily in marriage legislation, which is administered by Home Affairs. And then the Divorce Act would be aligned following the passing of that legislation, which will give recognition and recognize the validity of any marriage, so long as it meets the minimum requirements set out in that marriage bill. If there are amendments needed to the Divorce Act after the marriage bill is passed, those of course will be affected. But this is the reason why DOJ thought it would be better to pare down and restrict ourselves to the WLCT case. Also, in light of the fact that we need to meet the Constitutional Court deadline, and a more comprehensive reform would have taken more time and may have meant that we would not have met the deadline, or we would have not have been in a position to be able to meet the deadline. And so for those two reasons, we chose to confine ourselves. Thank you, Chair. If no.
Follow up, Mr. Hendricks.
Chair,
maybe the minister, deputy minister, going to answer the issues I raised, but the issues I raised haven't been addressed.
Okay, thank you. Deputy Minister.
Chair, look, I wasn't so much responding to Honourable Hendricks, but I thought that Ms. Botha had tried to do that. Some of the issues as to what has happened to the bill, Mr. Honourable Hendricks's bill needs to be responded to by the Portfolio Committee. But my understanding is that the department did look at his version of the bill, or his version. But just to say on the issue of other faiths, that the Honourable Swart raises the issue of Hindus and Jews. There's other religions, though, and the extent of what is a religion is something that would need to be defined by law, and I imagine that would be quite complicated. So there's Rastafarians who I understand conduct marriages. There's Baha'is who conduct marriages. The issue, though, is that, as I understand it, and I speak under correction, the law currently is that a marriage has to be conducted by a marriage officer. So you can have a Christian marriage, which becomes lawful because it's been conducted by a marriage officer. And from the apartheid government's period, the main Christian denominations, if you were a priest or a minister of that denomination, you automatically became a marriage officer. Home Affairs has been trying to encourage mulanas to register as marriage officers, as other people, and if they are registered as marriage officers, they can conduct a Muslim marriage, and it's then still lawful. But the issue would also affect ministers, Christian ministers, who are not marriage officers, and that's something that the Home Affairs Bill is trying to address. The issue is that currently Home Affairs deals with marriages, Justice deals with dissolution of marriages. Home Affairs has taken over customary marriages, as far as I understand it, as well. The idea with the marriage bill that Home Affairs is working on is that will be including divorces. So divorces will actually come out of Justice's responsibility. But yeah, I'm not sure the other points from Mr. Hendricks on the divorce bill or his private member's bill. I think the committee would need to respond to what it's been able to do. But the intention was originally that we wouldn't have to do this divorce amendment bill that has been introduced by the department or by the minister. Home Affairs would take care of it in the marriage, marriage bill that they're working on and have published for public comment. Thanks, Chair.
Thank you. I think with respect to the issue raised by Honorable Hendricks on us calling the South African Law Reform Commission, I think he is quite aware that this is our first meeting after a long constituency break. We are still going to, since we are starting now, we are still going to call them to give us an update as to how far they are. Everybody was on constituency break, so we couldn't do it. But we think for now, the focus is on this bill that is before us, and we have invited public comments, and bearing in mind that this is a bill that is more or less a stopgap measure, as we are still going to be dealing with a comprehensive marriage bill. In fact, that is Parliament through the Portfolio Committee on Home Affairs. I think we would need to interact with that process once it is before us. For now, it would be important that we deal with this bill, which is a stopgap measure to meet the Constitutional Court deadline. And when we come back, during the process of the BRRR, it is only then we will have time to invite the South African Law Reform Commission to give us an update as to where they are with regard to the issues that Honorable Hendricks raised. I hope that clarifies you, Honorable Hendricks.
Honorable Chair, the Deputy Minister said that you have to deal with the private members' bill, why nothing has happened, and that this bill is now trumping the private members' bill without any reference, without reference to the private members' bill, which does have a certificate of constitutional muster, and which just seems to be in the air at the moment. Both bills deal with the Constitutional Court order, So I don't think it is fair on your part to suggest that we must only stick to the bill before us. We have to take into consideration the private members' bill and the amendments. And the minister did allude to the fact that they had a look at the private members' bill. You can't leave a private member's bill in limbo, Honourable Chair, with respect.
Are you done?
Yes, Chair.
No, thank you very much. Members, I suggest that we will have time to comprehensively respond to Honorable Hendricks after we are done with this briefing. We will respond as to how we have processed the issue of the private members' bill. We will respond to you, Honorable Hendricks. Thank you very much. Members, that brings us to the end of the meeting. The meeting is adjourned.
Thank you, Chairperson.
Thank you.
Thanks, Chair.
Thank you.
Recording stopped.